Court will now call the case of 120350, State of Kansas versus Charles D. Bowser.
May it please the court, I'm Deborah Wilson of the Capital Appeals and Conflicts Office, appearing on behalf of the defendant appellant Charles Bowser. Chief Justice Lukert, I'd like to request 3 minutes rebuttal time this morning.
3 minutes is granted. Thank you.
Thank you. Charles Bowser was convicted in Wyandotte County of numerous offenses arising from 2 armed robberies. He was convicted of aggravated robbery, aggravated battery, criminal possession of a weapon, but the most serious is his conviction for attempted capital murder, for which he received a life sentence, hard 25, and he's also serving about 38 additional years consecutive to his life sentence, and this is his direct appeal. Today I'd like to start with discussing the trial court's erroneous answer to a jury question about the instruction that defined the elements of attempted capital murder. But first, let's recall that if Charles Bowser was the robber in the Eagle sweatshirt at the 7-Eleven, as the state alleges, Charles Bowser was the one robber who did not shoot at Deputy Wood. He had already left the 7-Eleven without shooting anyone before Cecil Megerson and then Dyron King shot at the deputy. Now, the state's theory was that he aided and abetted them in an attempted premeditated murder. This means the state had the burden of proving that he intended that Deputy Wood be killed and that he premeditated this killing. And given the circumstances of the shooting, that this didn't happen until he had left the convenience store, this wasn't going to be an easy task for the state. But the trial judge relieved the state of this burden when, in answer to the question, instruction number 10 defined whose conduct he was criminally responsible, he replied, Cecil Megerson and Dyron King. That answer was wrong and it was improper, and we believe that the problem started, but didn't end, with the judge misunderstanding the question. We contend that the jury was asking for guidance on the issue of when one person is criminally responsible for the acts of another, while the state disagrees, saying that the parties all thought that the jury just wanted the names. My best argument for our position on appeal is the actual question as it is written, which defense counsel never saw, which explains the lack of objection in this case. If you look at page 21 of volume 24 of our record on appeal, that question from the jury states, instruction number 10, define, and then in quotation marks, we have the phrase, whose conduct he was criminally responsible. Instruction number 10 contains the elements of attempted capital murder, which repeats several times the phrase that the jury put in quotes, the defendant or another for whose conduct he was criminally responsible. That's the phrase the court was asked to define. And the court misconstrued this, saying, oh, they mean to ask whose conduct he was criminally responsible for. The word for isn't there, and it's not there because it's not in the phrase that the jurors wanted explained. Criminal responsibility based on aiding and abetting isn't an intuitive or a common sense idea that lay people come into the courtroom already understanding. And it makes sense that the jury asked for some guidance because they were being asked to decide whether Charles Bowser could be found guilty of committing an act that everyone agrees was actually carried out by King and Megerson. So what's the jury to think? We want to know what this means, for whose conduct he was criminally responsible, and the judge just told us it means King and Megerson. So Bowser is criminally responsible for the acts of King and Megerson shot Deputy Woods, so Charles Bowser is guilty. Under that answer, which acts as a supplemental instruction to the jury, the question of Mr. Bowser's intent, the question of Mr. Bowser's premeditation isn't an issue, because under that instruction, he's guilty of attempted capital murder if King or Megerson premeditated. What the court should have done, of course, was refer the jury to instruction number 44, which explains aiding and abetting, and which, more importantly for this case, tells the jurors that Mr. Bowser had to have the requisite mental state, intent, and premeditation in this case, in order to be responsible for King and Megerson's actions. And even if the trial court was correct that the jurors wanted to know whose conduct he was criminally responsible for, King and Megerson's still the wrong answer, because it was up to the jury to decide if Bowser was responsible, if he had that culpable mental state for what King and Megerson did. So turning to the prejudice question, would the jury have returned a different verdict on the attempted capital murder if the state had been required to meet its burden of proof on the culpable mental state, premeditation, and intent? We contend no, because there was no evidence that those robbers went into the 7-Eleven intending to kill anyone. First, there's no direct evidence. We don't have any evidence of a plan or an understanding among the robbers before they entered the store. And the circumstantial evidence is also against it. If the robbers had planned to kill witnesses, they would have shot the deputy as they came in to eliminate him as a possible impediment to the robbery, and they would have shot the clerk after he had opened the register for them. If the robbers had planned to kill witnesses, why didn't the robber in the Eagle sweatshirt help them and make an attempt to kill witnesses before he left? If the robbers had planned to kill witnesses, why wait until the 7-Eleven robbery to put this plan into action? They had successfully robbed several other convenience stores without trying to kill anyone. There's no evidence here that the guy who was in the Eagle sweatshirt learned or figured out that King or Megerson was going to shoot the deputy on their way out and decided that he would help them. If you watch the video, you don't see any opportunity for communication or consultation between the robbers once they're in there robbing the store. Here's what the video does show. The robber in the Eagle sweatshirt thinks they're done and it's time to get out of there, and that's what he does. He has done what he came to do, which is rob a convenience store, and he leaves. Megerson takes it upon himself to shoot the deputy, and King follows suit. There's no evidence of a plan, and if King and Megerson's actions were a horrible surprise to the robber in the Eagle sweatshirt, then he didn't have the required the culpable mental state to support a conviction of attempted capital murder.
Counsel, can I back you up to the
Yes.
error question before we?
Yes.
You've moved to prejudice, but I want to back up to error. If the judge's answer had simply been prefaced with the words, "the state alleges," would that have been correct in your view?
Well, if they really did want to know who are you saying he was responsible for.
Let's set aside speculating
Yes.
on what they wanted to know and
Yes.
just look
Yes.
at the somewhat ambiguous question that was asked. If the answer had been, "the state alleges that your client is criminally responsible for the conduct of King and Megerson,"
I would say no, because I think that written question makes it very clear that they didn't understand this idea for whose conduct he's criminally responsible. So I believe that the correct answer would be to refer them to instruction 44 and tell them, if instruction 44 doesn't clear that up for you, then come back. So I would say King and Megerson is the wrong answer under any circumstances.
And what standard of review do we apply to that question?
Plain error. We're applying plain error. Or, well, I guess you can answer the question of whether the answer was correct or not. I think you can do that de novo, because I think that's a question of law. But I think obviously in prejudice, we have to apply plain error.
Typically, when there's a jury question, counsel and defendant are present, state's present. and there's a back and forth between the court and counsel about what does the question mean, what's the appropriate answer. There doesn't seem to be anything along those lines here. What relieves counsel from his or her obligation to object at this point, or to at least seek clarification on what the question is? I don't see that in the dialogue, and then there was no objection to the answer.
Right, and that puts us into the area of the plain error review, which gives me a pretty steep hill to climb here on the prejudice prong. But when you say that the counsel didn't object, if you look at the transcript, the judge first read the question into the record, but he omitted those quotation marks. So that's the first indication that defense counsel had about this question, read the question without quotation marks. And then defense counsel said, would you read that again? And this time the judge didn't read the entire question. He responded by saying, question is, quote, whose conduct he was criminally responsible, end quote. And the judge said that, quote, and end quote. But he didn't make it clear when he read that the jurors said define and then put that phrase into quotes. Defense counsel could have thought that when he spoke those quotation marks, he was just indicating that he was quoting directly from the question. But to answer your question, Justice Rosen, his failure to object isn't fatal to us looking at whether the answer was correct. But his failure to object does put us into the plain error standard of review. In this case, this instruction to the jury that Charles Bowser was criminally responsible for anything King and Megerson did, that acted as an instruction to the jury, and that's why we claim the instruction infected all the convictions for the counts where the question phrase appeared, and we're requesting reversal. Turning very briefly to the sentencing issue, we don't claim that Charles Bowser had the right to a 35-year sentence. We do claim that he had the right to an unbiased, neutral, and detached judge at sentencing, and we do claim that Judge Burdett should not have been the sentencing judge in this case after his strong advocacy for the plea offer came to naught. And we do claim that the sentence imposed in this case, the maximum possible after Judge Burdett threatened the maximum possible should he reject the plea, gives rise to a presumption of vindictiveness that's not countered by the record, and it should be vacated.
What's the difference between in the posture the case was at when these discussions occurred? That's the kind of the pre-trial, and the trial judge is saying, look, I've tried the two co-defendants, the evidence, and trying to persuade or to say and to ensure that your client understands the consequences of going to trial and what he believes is strong evidence versus taking a plea. What's the role of a trial? Should the trial court judge just not engage in any discussion? Is it proper to engage? What's your position on that?
My position that it's certainly proper to inquire to make sure that the defendant knows that there's been a plea offer, that he understands the terms of it, that he understands the possible penalties should he lose at trial. However, in this case, what we have here is that Judge Burdett predicted he would lose at trial, predicted he would impose consecutive sentences if Mr. Bowser lost, described the advantages of the plea offer in glowing terms, misstating Mr. Bowser's appeal rights should he take the plea offer along the way, and held everything up to encourage Mr. Bowser to speak with his mother. And Mr. Bowser said, I still want my trial. When he did that, Judge Burdett said this, I can't convince you anymore, and I'm not going to talk to you anymore about it. I guess I've done the best I can to try to convince you otherwise, and you're choosing to do that, and I understand. He has now abandoned his neutral and detached role as the trial judge, becoming an advocate for and a strong proponent of the state's plea offer. Once he threatened Mr. Bowser that he wouldn't get out of prison if he didn't take the plea, he should have stepped back from the case, because anyone hearing that, he told Mr. Bowser that at sentencing, and then and then at sentencing stacked the sentences so he in fact wouldn't get out of prison, would wonder, is Mr. Bowser being punished for exercising his right to trial? I see that I'm out of time.
Is in examining whether or not the sentence was vindictive, is it appropriate for us to look at what the other defendants' sentences, how they parallel with your clients?
I've certainly pulled the other defendants into the analysis here, and it is true that Mr. Bowser was sentenced in roughly the same way as the co-defendants. There were some differences, I think, because of criminal history and particular offenses.
But in terms of the consecutive nature.
Right,
they
in
were the
terms of the
same.
consecutive. And Judge Burdett said that I'm basing the sentence on the nature of the crimes and the impact of the victims. But here's where that other trial comes into play. He'd already presided at the King and the Megerson trials, so he knew the nature of the crimes and he knew the impact on the victims when he tried to convince Mr. Bowser to take the plea for 35 years, signaling knowing the impact on the victims and knowing the nature of the crimes. 35 years is a sentence that I approve of and think is appropriate for the nature of these crimes. And of course, there is a huge distinguishing factor between Mr. Bowser and Megerson and King. If he was the robber in the Eagle sweatshirt, which we don't concede, he's the one robber who didn't shoot at Deputy Wood.
So I take it from your answer, you don't have a quarrel with us looking at the other cases.
I don't, and I think it swings my way when you do.
Any other questions? Okay, thank you. Mr. Obermeyer?
Counsel, Madam Chief Justice, may it please the court, State of Kansas, by Assistant District Attorney, Wyandotte County, Daniel Obermeyer. In this case, it was a series of robberies across state lines in Kansas City, Kansas and Kansas City, Missouri that occurred over the period of February 27th to March 4th. The majority of these robberies occurred on March 3rd and 4th of 2015. At late night, early morning hours. So really we're talking a series of robberies over a period of hours. I'm going to discuss first, just briefly, the facts surrounding the 7-Eleven incident because that concerns Judge Burdett's answer to the jury's question. And we've sort of raised tangentially a sufficiency of the evidence argument, although that was not raised in the brief. And then I'll address the arguments as they present themselves in the brief. Essentially, what the evidence showed at the 7-Eleven robbery was what was showed at the other robberies that the state produced a lot of 6455 evidence in. These three robbers, they come in to convenience store, they have their guns drawn, they're wearing distinctive clothing. Under the state's theory, Mr. Bowser at the 7-Eleven was wearing a gold eagle on a black jacket, sort of hoodie type thing. He also had these gloves, black gloves with gold lining on them, and he was the second person who entered the 7-Eleven. He was one of the individuals that drew his guns. He had his gun pointed at Deputy Wood. When Deputy Wood saw these individuals entering, he went to the ground to show that he was not a threat to them, that he was not resisting their actions. And then these defendants proceeded to beat him, to disarm him, and then two of them eventually shot him. Once in the head, and then there were many other times. I think he had 15 laceration wounds, and as a result, he suffered very serious injuries from that. These events were all captured on camera, all the robberies, so the jury could review all of these modus operandi, the distinctive clothing, the actions in general of each of the robbers in these events. The jury considered all this evidence and found Mr. Bowser guilty of attempted capital murder and all the other charges against him at that time. And the state was able to connect Mr. Bowser and his co-defendants through DNA evidence, there was a series of there was just a lot of circumstantial evidence which connected him to this case. Addressing the first issue as whether or not the sentence imposed upon Mr. Bowser was the result of judicial vindictiveness. I haven't been able to find Kansas case law on this. Both counsel and I cite the Wilson case out of Florida, and that concerns cases where judges enter or they involve themselves in some way in plea negotiations, and to whether or not that gives rise to the inference that the sentence imposed ultimately on the defendant was the result of vindictiveness, whether that was imposed because of the defendant's choice to take the matter to trial in that matter. And the four factors are whether the judge initiated discussions, whether the judge departed from his role as a neutral arbiter by urging the defendant to accept the plea, or stating that the sentence imposed would hinge on whether or not he exercised his right to trial, the disparity between the plea offer and the actual sentence, and the lack of any facts that would explain the difference between the sentence imposed and the sentence offered in the plea. It's the state's contention that none of these factors actually weigh in the defendant's side on this. First, as the record shows, the court didn't initiate plea discussions in this matter. The state had offered a plea to Mr. Bowser, basically 35 years, which would take this matter from an off-grid offense to on-grid offenses. And the judge was ensuring that the defendant knew that this was what the state had offered, that he was, instead of facing a life sentence, he was facing a sentence where he would have the possibility of life.
What do we do? And I think it is a fine line between what is just advising Mr. Bowser of his of what he's facing and what the consequences could be, and then misinforming him about his rights, which is a problem. And what I mean by that is he said he could take any concerns that he had with the plea or his defenses and appeal those. That is completely wrong. And what do we do with that, or anything, since he didn't take the plea? But how far can a judge? It can't go as far as to misadvise him of what the consequences are.
I understand. That's when you have to look at these other factors. I think that what's the effect of that? And that's the question that these other factors address.
What's the effect of misadvising him?
Yes.
Okay.
And
Here the effect was nothing because he refused to take the plea.
yes.
Right.
I mean, so even if he erred in that respect, and it looks like he did, the defense falls down on harmlessness on that particular problem.
Yes, I would say so. I don't think there's any prejudice to the defense in that matter. I mean, I'm not defending, him saying that. Clearly, I think that there's a lot of things that you can pursue, that defendants can pursue on collateral appeals by simply catching an issue as an effective assistance of counsel issue. They were ineffective to do.
They are, but there's a higher standard.
I understand.
Yeah.
And I don't mean... and I'm not,
Collateral attack is not an equivalent of an appeal.
I understand, and I'm not trying to argue that point at all, but I can see where he was going on that, what his thought process might have been.
I think the defense's point on this misinforming about the appeal rights is not that it had an effect, it's that it's evidence or symptomatic of the judge's zeal to get a deal. And so that's where, and that's the one thing that kind of stands on the other side of the ledger. I mean, I read what the judge said here, and I think the judge is really just trying to make sure this guy, in all fairness, understands what he's got in front of him, and not that he's invested in the answer. But then you have this misinforming thing. So, balancing all of that, what do you do with it? And you want me to ignore it.
It's not that obviously we don't want judges misinforming defendants of their rights in any circumstance. However, ultimately, and really I'm glad to hear that you're not reading into this as the judge just sort of hammering a plea away, because I don't read into that either. it seems like he's trying to be very thorough, that he understands that instead of getting a life sentence, you're getting a term of years sentence that you can see outside of that. And I think that he might be generally amazed that the state even offered that, given the facts that he knows, the evidence that he knows the state can present and had presented against his co-defendants. So I'm not sure, in terms of a remedy for Mr. Bowser, that there's anything that this court can do, because I do think ultimately it's a harmless issue.
And how do we judge that? How do we make that determination? Just looking at the fact that it is a sentence that was allowed by the law, and that's the end of it, or?
That is certainly one factor. Also at sentencing, as I note in my brief, both Scott Wood and his wife requested that the court impose the maximum sentence. Obviously, the words of the victims, I think that's very powerful. The state also requested that the court impose the maximum sentence. The defense presented no evidence in mitigation of why he shouldn't receive a consecutive sentence.
What was the procedural history, if you know it, in terms of where this fell in relation to sentencing on the other two cases? Had that occurred yet by the time of this discussion?
Yes, I do believe that it had. I believe that it had occurred some months before. I couldn't tell you exactly.
King, at least in our process, was ahead of the others. But I
Yes.
don't know if that's just because of briefing or because of timing of the jury trial.
I think that was just because of briefing, because King and Magerson were in the same trial. They had a joint trial. And Mr. Bowser, because his counsel entered at a later date, was granted a continuance on that. So essentially,
So the judge also knew what sentence he had imposed, at least on King and...
at least on King and Magerson. And as I said in my brief, the reason why that Mr. Bowser received a slightly higher sentence is because there's a slight difference in the crime of conviction that enabled that. Unless there's any further questions on issue 1, I'll move on to issue 2, the prosecutorial error arguments. The brief raises...
Can I just ask one more question?
Certainly.
A theoretical one.
Certainly.
Even a judge who's attempting to be benevolent can overstep and leave the role of a neutral and detached magistrate, right?
Yes.
And that also is a problem.
Yes, I think, yes. And as a prosecutor, I'm aware of that.
Okay.
So, sensitive to that, I should say. And one more point I want to make on that. There's just a dearth of case law as to what judges can or should or shouldn't do in these sort of circumstances, what their role is. So, as terms of abandoning his role as a neutral arbiter in this matter, I just don't think that there's really that much guidance to come down on, and I'm sure some guidance would be appreciated. The prosecutorial error arguments, very quickly. In a nutshell, all of the arguments except for the statement about the car being seen at the robberies, those are all supported by the evidence. And the statement that defendant complains of, where the prosecutor states that essentially the defendant's car was seen at the robberies, that was, I would argue, that was a one-off, that was a minor aberration, and it was unrepeated, and it was contradicted by the interactive internet exhibit. I believe that states 541 in this case, and that's included on the record on appeal.
Do you agree that that was error then?
Yes, I do agree that that was error. I think that's a misstatement of the facts. But like I think that was an unintentional error. It was unrepeated. And ultimately it was harmless, both because of the state's evidence presented showing that clearly the cars, under the state's theory, it's only at one of the robberies, or at least a car similar to it is at one of the robberies. But also in light of the argument of defense counsel that the car was seen on the car was used in all the robberies to that effect. And his argument is that Mr. Bowser is the victim of poorly choosing his friends, essentially. So that's really not a fact in dispute as to whether or not the car was used. Also, the car contained much of the incriminating evidence that the state used in its case in chief. As regards to the argument in the brief that the state misstated the evidence by not noting the minor profiles, my contention would be that the state was drawing attention to the major profiles. The prosecutor said this complained of statement is basically Mr. Bowser's DNA was found inside the yellow and black glove. I believe the testimony was it was more than a cotillion, and that's another misspeaking there. He's the only possibility of the person who was using the glove as a major donor. Let's look at the glove, because after he finished wearing the gray hoodie, he switched out and put on the hoodie with the eagle. He put on the same glove with the gold around the wrist and the gold in the middle, and you see the gun in his hand in the same glove that the only person on earth could possibly have that DNA. That's Charles Bowser's glove. And he's referring to the very large frequencies that occur. The defendant's DNA was the only one found on the major DNA profile, was the only one found on the black glove. And there were some minor profiles found on the gray shoes that included another person, and also the minor profiles on the Mizzou mask and the blue fabric found in the defendant's car.
Given the limited time, I'd like to ask you what your response is to whether or not the judge's response to the jury question essentially allowed them to ignore instruction 44?
I would say that it did not. And I'd say that for, first I'd say that the judge, the standard review that this court should exercise is an abuse of discretion.
Even as to the whether or not it was an appropriately legal response?
Well, if it's an appropriate legal response, of course, that's de novo that you can exercise review over. So if he basically...
But as one of the three prongs of abuse of discretion?
Yes, correct. So...
Alternatives, I guess is a better way to say it. Okay.
Yes, one of those three. So initially, yes, on page 1145 of volume 5, the court reads in the question, instruction number 10, define whose conduct he was criminally responsible for, and he discusses this with counsel, and he proposes the answer of what the jury is looking for is the names of the co-defendants. And there's really not much argument that that is indeed what the jury is asking.
Is that a reasonable way to read the question? I mean, so under that theory, everyone had to understand the question to be asking essentially, who is the state alleging? Who is the state alleging that Bowser is responsible for their conduct?
And I think everyone did understand that that was what the question was asking, because defense counsel says, well, our argument would be that one, he's not involved at all. Two, this other person, this DeAndre Harris, he might also be involved as well. And the court, why he gives the names of co-defendants is because that's reflected in the charging document. So in the court's mind and in the minds of counsel, what they're asking for is if the these two individuals, Cecil Magerson and Dyron King, if you find that all of these other elements are met in terms of aider and abettor liability, then you can also find Charles Bowser guilty. And they were properly instructed on accomplice liability. And while the judge could have said, I can only refer you to jury instruction, I believe it's 44 was the accomplice liability instruction, the jury was clearly asking a question for clarification. And the judge says, I think that from the record you can see that one of the foreman starts to ask another question to clarify, and the judge says, no, if you have any other questions, send it to us in writing. And
Does he get any of the question out, that juror who's trying to follow up? It seems, how long did this trial go on?
This trial lasted, I believe, 5 days. It ended on a Friday. It started on a Monday, I believe, and ended on a Friday.
How could the jury have any question in his mind at the end of those 5 days who the state was alleging he was responsible for? I mean, it just seems unfathomable to me. For the question to have been interpreted in that way, I just seems very peculiar.
Well, I mean, by the same token, it's a little unfathomable if the jury's just asking the court to repeat, define whose conduct he's criminally responsible for when they have an instruction
A
saying
whole
that.
instruction on aiding and abetting.
So, I mean, I'm not trying,
How well are those two instructions linked, though? When you think about it from a layperson standpoint, we understand it, but I'm not. This causes the question to think about how the wording of those instructions may intersect, and whether or not it's really clear to a layperson reading these. Okay, from here I go to instruction number 44, and I don't know. Maybe the closing arguments help them make that link. I'm not sure.
I'd have to rely on the record. I mean, I'd have to fall back on the record as to how far they're connected. I do know that the aider and abetting instruction does have that definition for whose conduct he's criminally responsible.
Would it be possible for a juror to get that judge's answer and think to him or herself, okay, this defendant is criminally responsible for the conduct of King and Megerson?
I don't think so, because the instructions still require that he has to act with the same intent that they act as well. He has to share their.
You're just saying instruction 44 is still there.
Yes, I would say that.
And we assume they follow all the instructions.
But why wouldn't the jury think that had been shortcutted? But the judge's answer let them off the hook of having to walk through that, because the judge had said they were responsible for the actions of those two people.
Well, I respectfully disagree with the assertion that the judge was saying, if you find his exact quote is on page 148 and 1148 and then the 1149. I'm going to read this into the record. Instruction number 10: define whose conduct he was criminally responsible. End quote. The only way I can answer that question is by giving you the names of the two co-defendants, and that would be Cecil Megerson and Dyron King, period. So he's not saying Charles Bowser is responsible for the criminal acts of Cecil Megerson and Dyron King. He's saying that the co-defendants in this case are these two people.
I think you're right that is what the judge is saying, but the question is whether there was miscommunication in the way this question was asked and the way it was answered.
Well, if there was miscommunication, the next thing that the judge says, can't ask me anything else unless you put it in writing and date it. So
you're saying that provides at least some indication that there was no miscommunication because the jury got the answer they were looking for.
They must have, because they didn't ask another question. They deliberated the rest of the Friday, and then they took the weekend off, then they resumed their deliberations on Monday, and then they rendered a verdict after lunch on Monday. So if the answer was interpreted the way that the defense counsel says it should have been interpreted, or it was interpreted, then the jury would have rendered a verdict almost immediately. It would be my argument, rather than sitting around apparently at least half a day and considering the evidence that had been presented to it.
Do we know how long they've been out when the question was posed?
I don't believe the record reflects that, unfortunately.
Do you think it's possible the jury was considering holding Bowser responsible for what Harris had done?
Well, that's a harder question because the state didn't allege that DeAndre Harris was involved in these crimes. The argument that there was evidence connecting DeAndre Harris because DeAndre Harris is found some weeks after the shooting of Deputy Wood, and he has Deputy Wood's service weapon. And of course, that's very strong evidence that he might be involved, but eventually investigators ruled him out. And his DNA really wasn't corroborated, or none of the other evidence corroborated that DeAndre Harris was present, really, except for the gun. That was the best evidence that he was involved.
He ended up with the deputy service weapon, right?
He did end up with the deputy service weapon.
Yeah. Okay.
Okay.
Thank you.
I'm out of time. In closing, I would just respectfully ask this court to affirm the verdicts and to affirm the sentence. Thank you for your time.
Did you hear what Mr. Overmeyer accidentally said when discussing this jury question? He was trying to relate the question from the jury verbally, like Judge Burdett did to trial counsel, and he said, define whose conduct he was criminally responsible for. And that's why defense counsel, like everyone else, was confused about the nature of this question.
Well, that seems to me to be essentially a concession on your part that this question's ambiguous. And if that's true, what should a judge do when the judge gets an ambiguous question from the
Well,
jury?
the problem is Judge Burdett didn't think it was ambiguous. He thought they want to know whose conduct he's responsible
He
for.
discussed it with the attorneys,
Right.
and if it is ambiguous, then that's one reasonable way to read the question. And if you discuss the question with the parties and everybody seems to interpret it the same way, why isn't that within the judge's discretion?
Because he did misinterpret the question, and when you see the question as written, as Judge Burdett did, there is no question. First of all,
you're saying it's not ambiguous.
Yes, and they're saying they didn't say name whose conduct he was criminally responsible. They said define, and they put the phrase directly from the instruction.
So do you think this question was ambiguous?
No, I think that Judge Burdett.
How can? It just seems to me like one reasonable interpretation of the question is the way the judge and the attorneys interpreted it.
And I disagree with Judge Burdett's interpretation of the question. And remember,
you also made the point that the lawyers didn't see the question.
They didn't see the question. I think that defense counsel would have said, that's not the question that's being asked if he had seen the question as written.
But didn't Judge Burdett also, to mitigate that point on your side, didn't he also make a reference to the fact that the word for wasn't in the question? And that must be what they meant?
That must be what they meant, is what he said.
And even if it is, that interpretation was a plausible interpretation of the question, was that the right answer?
No, because once again, that short circuits the jury determination, because it's up to the jury to decide if Charles Bowser helped Cecil Megerson and Dyron King with intent to kill and with premeditation. And so if the jury wants to know, Judge, whose conduct is he criminally responsible for? And he says King and Megerson, obviously that's an improper answer because it invades the province of the jury, much like that other case in which Judge Burdett answered a jury question. They were wanting to know if the state alleged there was an incident that happened more than once, and Judge Burdett said, yes, it happened 2 times, and this court reversed in that case. And remember, the foreman did try to say something when he came back with the names of the co-defendants, and the judge cut him off and said, you can't ask me anything else unless you put it in writing. But he had prefaced that by saying, the only way I can answer your question is by giving you the names Cecil Megerson and Dyron King. Judge Wilson, you brought up an interesting question about DeAndre Harris. Of course, Mr. Harris was found 1 week later with Deputy Wood's service revolver in his possession. He was the cousin of Dyron King, who I would argue had the most incriminating evidence against him, that blood evidence, Deputy Wood's blood on the gun that was found in his possession. And one of the most interesting things about this is when reading the facts, you wonder why DeAndre Harris wasn't looked at seriously as a suspect in this case. And the police explanation at trial was, well, he was too short to have committed these robberies. Well, remember, the Family Dollar was robbed immediately before the 7-Eleven in this case. And the witness from the Family Dollar, Patricia Pope, said that the 3 robbers, she described them in this way. There was a tall one, there was one about my height, and then there was the little one. She described the little one as being shorter than she was. She's 5'4". And so the little one was short indeed. The record shows that DeAndre Harris was 5'3". So we think he is the strongest candidate in this case for the role of man in the Eagle sweatshirt, since the other two robbers at the 7-Eleven had the King gloves and the Megerson gloves on, respectively. So for those reasons, I think that Mr. Harris was a good candidate for being a participant in this robbery as opposed to Charles Bowser.
But wouldn't that lend more credence to the argument that it was ambiguous because the judge and both counsel were thinking, whatever you decide, in holding criminal responsibility on Bowser, it can't be anyone except Megerson or King. It can't be Harris. It can't be some of those other people whose DNA or minor DNA may have been mixed up in the evidence.
So your point is that maybe the jury was considering DeAndre Harris and they were wondering if Charles Bowser could be found guilty of something that they believed DeAndre Harris was participating in as opposed to Charles Bowser, if I'm understanding you correctly.
As opposed to Megerson or King.
As opposed to Megerson or King.
Right.
I still think that when you look at that question, page 21, volume 24, when you look at that question, you'll see there's no room for ambiguity. Not when I was working on the first draft of this brief, I hadn't seen the question yet, and I remember saying to Mr. Nelson, wouldn't it be great if that jury question had quotation marks around the phrase? And I got the jury question, and there were quotation marks around the phrase. And I think that makes it perfectly clear that he just answered the question incorrectly. Thank you.
Thank you, counsel. The court will take this matter under advisement.